Mr. Tupper.
Thank you. May it please the court, counsel. My name is Tim Tupper. I'm an attorney from Davenport, Iowa. I represent J.C. I represented J.C. in the adjudicatory hearing where he was adjudicated a delinquent child as a result of assault with intent to commit sex abuse finding. Sixth Amendment to the Constitution prohibits the introduction of testimonial statements of a non-testifying witness unless the witness is unable to testify and the defendant had no prior opportunity for cross-examination. The present case, J.C., was found guilty of assault, as I discussed. He was roughly 12 at the time. The court in that hearing heard testimony from several children, but not from the alleged victim, A.W., who at the time of the alleged event or the event was 4 and at the hearing was 5. Instead, the court heard testimony of statements made by A.W. to employees of the Child Protection Response Center, Michelle Maddox, and Dr. Barbara Hari.
I get a factual clarification, Mr. Tupper.
Yes.
It looks like, reviewing the record, that there were 2 interviews on 2 dates. Is that correct?
That is correct, Your Honor.
So that A.W. spoke with Maddox, it sounded like July 10th, 2013, and then Dad brought her back and she spoke with Dr. Harry, I don't know how to
Dr.
pronounce
Hari, approximately 3 weeks later.
Approximately 3 weeks later. Okay.
Yes. In fact, what happened was there was an emergency room visit, there was a police investigation, and then several days later, after referral to the Child Protection Center, the forensic interview was conducted by Dr. Hari, or by Michelle Maddox, and then followed up with Dr. Hari. At hearing, the statements made by A.W. to Michelle Maddox and Dr. Hari were entered through testimony and through reports, and the court also admitted the videotape of Michelle Maddox's interview. As noted,
I thought the court did not admit the videotape, reading the record.
You would be correct, Your Honor. I'm thinking of a different case, but you're right, the court did not admit the videotape. The forensic interview conducted by Michelle Maddox was subsequent to the investigation. At the hearing, she testified to the nature of that forensic interview. She testified to her forensic training, approximately 40 hours of training in forensic interviewing technique, followed by an additional 32 hours. Included in her discussion with the child was a discussion of the concepts of truth and lie. The forensic interviewer, in this case, received information from the police prior to the interview. In fact, law enforcement was present for the interview. The interview was recorded and provided to law enforcement and to the county attorney. Also, the report was provided to the county attorney. As noted, approximately 3 weeks later, Dr. Hari also met with A.W. Dr. Hari testified that where the forensic interviewer, Michelle Maddox, finds there would be benefit from a medical assessment, that information gets communicated to the parents and to law enforcement.
Also, Crawford applies only to testimonial statements made out of court, and the question arises: is this a medical procedure, a medical process? Was this interview used in aid in diagnosis and treatment, or was it a part of a investigative process of law enforcement?
I think that's an excellent question. In this case, as you may recall from reading Dr. Hari's report, she noted at the very end that she spent roughly 4 hours of time during this process. There was an initial exam in an interview room. You may even note from Dr. Maddox, or from Michelle Maddox's testimony, that they actually fight over that interview room. An interview proceeds. with respect to history. She goes through truth or lie concepts also. Actually looks very much similar to the kinds of questions and elicits the similar kind of information that Michelle Maddox elicited 3 weeks earlier.
Question, because as I read the interview report, I did notice that thing about the time. At the very end of the report, Dr. Harry says, and it's addressed to the assistant county attorney. At the very end, it says, face-to-face time with the patient and family involved 1.5 hours. Report creation required 2.5 hours of time. Was she billing the county?
I don't know if she was billing the county. What at least part of the source of revenue for the child protection centers is grant money provided by the state of Iowa. And as part of that, that may be part of their billing time. In any event, I don't know that I've ever had a doctor's appointment in all my years where the doctor has taken 2.5 hours to write a report, or spent a total of 4 hours in terms of the analysis of what I might need. I mean, clearly this is part of the investigative process. Dr. Hari went to great pains to identify all the reasons why this child would be truthful. And again, followed up in relatively the same fashion as Michelle Maddox in terms of the interview that takes place. She then goes on and has a physical exam of the child. It is of course of note that she only met with the child once. Dr. Hari provided obviously a copy of the report to the county attorney. The other part, the end of the report, thanks the county attorney for allowing her to be involved in the assessment process. What else could it be but the investigative process we're referring to? Child Protection Center, like the center in Bentley, clearly has a primary purpose of the investigation of child abuse and the assistance of law enforcement, including helping the police and the county attorney. Bentley Court obviously notes that the Child Protection Centers in the state serve a valuable purpose. That doesn't change the Confrontation Clause issues that we face.
Let me back up a second. Does the Confrontation Clause apply to juvenile adjudications?
Ohio v. Clark, obviously that becomes an issue. It seems to me that the issue is one of competency of that child to testify. That was not an issue that was really addressed, frankly, other than for some...
But do confrontation rights guaranteed by the United States Constitution apply to an Iowa delinquency proceeding? And if they do, on what basis?
I don't know that I can cite you any case law. There's a series of cases that relate to social workers, interviewing.
Those are in when it's an adult court and it's a criminal proceeding. This is an adjudicatory proceeding in juvenile court.
I would argue the concept is exactly the same. And the implications for my client are very, very similar in terms of what this looks like. My client, as a result of that adjudication and disposition, has to...
I'm going to maybe try and help you out. I think in re Galt, the U.S. Supreme Court said that in juvenile proceedings, confrontation applies.
Okay, thank you. Any other questions about that issue?
No, but I have a question about Clark.
Yes.
This is the U.S. Supreme Court decision, very recent.
Yes.
Where the court said, statements by very young children will rarely, if ever, implicate the Confrontation Clause. And that was a case involving, I think, a 3-year-old. Now, there's some factual distinctions, certainly, between that case and this one. But in light of that language, what do we make of that in light of the fact this is certainly a very young child, someone who was 4 years old at the time and apparently had serious speech issues as well?
Well, Chief Justice Roberts identifies a number of issues in Ohio v. Clark. One issue that's identified is the age of the child. It seems to me that's a factual issue in terms of whether the child has the ability to understand the difference between truth and lie. And clearly the opinion of Dr. Hari and Michelle Maddox was that the child did. As I recall the interview with Michelle Maddox, it also seemed to suggest the child understood the consequences that would come out of this, at least in a general sense.
Counsel, when we're dealing with children, especially children of this age, isn't the inquiry always going to be first for diagnosis and treatment? And I mean,
Hence-
even though there might be a mix of an investigation for prosecution purposes, but wouldn't the motivation primarily always be to protect the child in the context of determining, diagnosing an injury and treating that injury?
Certainly if you're a parent in that situation, what you want is your child to be safe, and you want your child to be, to make sure your child is well. And so that's the basis for the emergency room visit. After that emergency room visit is done, what's the purpose for going to see a forensic interviewer?
Well,
What's the
but
purpose to go see
isn't the damage that we're talking about, exceed the whatever physical injury? We're talking about psychological injuries that can live with a child for a lifetime, and wouldn't that help explain the comment in Clark that it would be a rare case when we're talking about something other than a medical inquiry?
Put yourself in the position of a parent. You've taken your child to the emergency room. There's a concern about her mental health, her psychological health. Do you then go and make an appointment with a forensic interviewer who's going to write a lengthy report to be submitted to court? Or do you go to a psychologist or psychiatrist, of which Dr. Hari is not neither? The primary purpose here is clearly the investigative process.
Counsel, I'd like just your help on a piece of the record, and it relates to the Maddox forensic interview. I recall in Bentley that not only were the police present at the center where the interview occurred, but there was actually participation by the police officers in the interview through suggested questions. What does the record in this case show with respect to the police officers' actual involvement in the Maddox interview?
The easy answer is I don't know. Let me explain. I have two of these cases that I tried at roughly the same time. In one of those, I know that the videotape shows questions being pushed under the door. I frankly don't remember if it was this case or the other case. So I would ask you to look. Regardless of that, it seems unlikely that the police simply attended the visit after having provided information to Michelle Maddox and sat quietly. Didn't have any contact. Again, even if the record doesn't show it, to suggest that the police were not intimately involved in this process simply, it simply isn't consistent with my experience in juvenile court, frankly. Obviously, Ohio v. Clark, a different situation. You have a teacher with a 3-year-old child. They talk there about the primary purpose being to respond to an ongoing emergency. Its purpose there was not to create a record for trial, and thus not in the Confrontations Clause scope. Clearly, we were not responding to an emergency. JC and AW were not going to have any future contact. There was no ongoing emergency. We're talking about 30 days later when Dr. Hari does the examination, right?
Said what she was doing, and said in the report what she was doing was a medical assessment. Now, I agree it's de novo review for a constitutional claim, but the court below seemed to accept that. And do we owe deference at all to that finding?
No. Dr. Hari's primary source of income at the center is grant funding and involves a cooperation with law enforcement and the county attorney's office and DHS. Certainly, the county attorney's office understands how to create, if you will, the framework to try to move around the confrontation clause. We'll see if they have effectively done that. But certainly, the county attorney's office has provided advice in terms of the kinds of things, the magic words you would need to say. Wouldn't you expect that? In any event, we would ask the court to reverse. Thank you.
Thank you, Mr. Tupper. Mr. Kempkes.
May it please the court. I'd like to address Justice Wiggins and Justice Mansfield's question about whether the confrontation clause applies. Somewhere in my, I've cited the case of Carey versus Population Services, 1977. In a footnote, they say they confirm the rights of minors to include the right of confrontation, and they cite N. Ray Galt. With regard to Justice Heck's question about the Michelle Maddox interview, there is testimony that near the end of the interview, the police officer who had been observing it unknown to the 3-year-old or 4-year-old child requested the interviewer to ask a couple questions about the young girl's knowledge about a penis. That is the extent of the questioning. They didn't control, they didn't instruct, they had that, and she answered questions, and by that time she'd already given her statements indicating that the delinquent child had touched her breast area and her backside. But I think the Maddox interview is kind of a red herring in this case, because the juvenile court only considers Michelle Maddox's testimony in a light favorable to the delinquent child in the sense that there was no penetration. The real confrontation clause issue here comes in with Dr. Harry's report.
You're willing to, I mean, I guess your position would be with Maddox that, similar to what the Court of Appeals said, that it was harmless error if Maddox was error.
If it were error,
should just
correct.
Focus on Dr. Harry. Is
correct.
That right?
And you know, I noticed the dissenting opinion in the Court of Appeals made it sound like Dr. Harry and Michelle Maddox are the same side, different sides of the same coin. They're not, as the testimony came in this case. They're like ships passing in the night. Dr. Harry didn't even review Michelle Maddox's report in this particular case. And I think the critical fact here, has been pointed out in the questions to opposing counsel, is you start with the age of the child. If you look at Ohio Clark and you try and find what is a bright line from this case, which is difficult because it's a confrontation clause case coming from the United States Supreme Court, and they're not very good at spelling things out. But if there's a bright line to this case, I say it's a relatively bright line in the sense of young children are incapable of giving testimonial statements.
You read Justice Scalia's concurring opinion, though, they talk about it was just not testimonial. Now, they have all these other reasons in there, you know, age and everything else, but telling a mandatory reporter was just not testimonial. And I don't know how you get the age thing and all these other factors out of that case. I mean, they talked about them, but when you really boil it down and you read Thomas's, Scalia, and Alito's opinion, it seems to all go to the fact that it just wasn't testimonial, reaching it in different ways.
I think that's correct, Your Honor. I think they're saying that the confrontation clause under the common law was not implicated at all by statements by very young children. And I think the real issue here then comes...
I don't see the very young children added on there. I think when you tell a teacher or a mandatory reporter what happened, I think that was the key to the case. And if this kid was 16, I think you'd get the same result. The age didn't matter, and I mean, does it? If the kid was older, would you get a different result in that case?
Well, you know, there's multiple ways of looking at it. First of all, we've got 9 justices on the Supreme Court all agreeing that the age of this child is critical. It's critical in the sense that a child of that age is incapable of, or rarely if ever is the language, of giving a testimonial statement. Then they say, at the common law, and they say it's
That's not my question. The question is, would the result have been different in that case if the kid was 16?
well,
Talking to a
again,
mandatory reporter.
again, coming to from
Your best guess.
Okay, coming at it from a different angle, I don't think you can categorically say beyond maybe the ages of 3, 4, and 5, and 6. By the way, those are the ages at common law by which children could not be charged with crimes because they were incapable of committing crime. But once you get beyond that, you know, it's funny because the Supreme Court talks about an objective test of the totality of the circumstances, looking at the primary purpose on both the behalf of the declarant as well as the interviewer. But I think you almost have to take into a subjective analysis of it because, as you point out, there could be an 18-year-old who's the functional equivalent of a 2 or 3-year-old. I don't think it goes the other
Say
direction.
a 16-year-old with a 16-year-old mental capacity, would the court even have to discuss age to say that it didn't violate the Confrontation Clause because of who the statement was made to?
Well, no, in that particular case, no. But I think in this case, given the age of the child, it was a critical component of it.
Wouldn't you agree that if you compare, I mean, you've got the majority opinion that I think it was Justice Alito wrote, and then you've got the concurring opinion by Justice Scalia joined by Ginsburg. Would you agree that the majority opinion puts more emphasis on age, or almost suggests that the young age alone could be sufficient, or maybe does suggest that the young age alone, as opposed to Justice Scalia's concurrence, which kind of moves away a little bit from that.
Correct, Your Honor. I would agree with that. And I'd also put in Justice Thomas in his concurring opinion in that same group with Justice Alito, because he says young children are just not capable of making these kind of testimonial statements. So I think if you're counting on the Supreme Court, you've got 7 out of 9 justices agreeing on that fact.
Raises an issue that's a little bit collateral to the main issue, but has confused me, and that is in your brief you indicate that this young child was not available to testify because she lacked competence. And maybe I've misread the brief, and please correct me, but
It was not the state's best effort, let me put it that way.
well, if the child was not competent to testify, why did this testimony come in the first place? If she's not competent to testify at trial, would her statements at the forensic interview suffer from the same problems?
Now, are you looking this from a Confrontation Clause aspect, a hearsay aspect?
Well, actually, I'm just looking at it from the viewpoint of what I thought was your point in the brief, and that was that, and I may have missed it, but the point in the brief I thought was, well, she was not available to testify at the juvenile hearing because she was not competent. And that struck me, and I thought, well, if she's not competent to testify at trial, why would the evidence come in any fashion?
Okay, I think I can understand. I think there are 2 different tests that we're talking about. One is competency, the ability to understand the significance of an oath. The other test is the primary purpose test on the part of the declarant. Does that person have the capacity to understand that the statements that he or she is making to a third party can invoke the machinery of the state against her alleged abuser? And those are 2 separate inquiries. And I would think the second one is a little higher in terms of what needs to be shown. So if I understand your questions right, I think even though she's not a witness who will and this particular young girl had a difficulty expressing herself. In addition, she had significantly developmentally delayed speech. So they weren't, according to the testimony, particularly by Catherine Jackson in this case, said that you're not going to get anything from her on the witness stand.
But I think where Justice Apple is coming from, and I think Mr. Tupper kind of raises this argument in his brief, is it does seem kind of incongruous. You have a witness who, she is so incompetent she can't appear and testify in the courtroom, but yet when she talks out of court, we can bring those statements in and rely on them for the truth of the matter asserted. Now, I don't disagree that the case law seems to allow that incongruity, but you would agree it seems a little incongruous, right?
Let me put it this way. Again, I will say that there are two different levels of proof. The second thing is, with regard to Justice Wiggins' comment, it might seem incongruous as well for dying declarations, to come in without an opportunity to cross-examine. But, Justice Scalia and the Supreme Court in multiple cases have said those dying declarations are not covered by the Confrontation Clause. In the same situation here, these statements by young children are not covered by the Confrontation Clause. And you're still able to confront the evidence against you. You just can't do it directly with that particular witness. You do it through the interviewer by saying, why did you ask these questions? How come you didn't pursue this line of inquiry? You can attack that evidence. You just can't attack it directly. And it's not that defendants lost a particular right through Ohio v. Clark. It's that they never had it to begin with. And so I think they fit within that same aspect of dying declarations. It's not implicating Confrontation Clause concerns. I would like to point out as well, when we were talking about Clark and its statement about young children, which at some point they describe as preschool students, this 4-year-old falls within that description of a preschool student. It says, the majority opinion comes as close as you possibly can to having a categorical statement about young children, because they use language like rarely if ever, extremely unlikely, highly doubtful. Well, they could have easily have said, this 3-year-old child and every 3-year-old child, it's impossible for them to give testimonial statements. They didn't. They used this language. That indicates to me that it goes beyond that it includes children 4, 5, 6, clearly includes that. And I say that based upon the common law when I was talking about the capacity to commit a crime, but also with regard to the testimony in this particular case from the psychologist Katherine Jackson, who references a study about 6 years, children 6 and under. And it has to do with their ability to be able to testify in court and understand the significance of an oath. But a lot of that is applicable to the idea of making a testimonial statement. And what she says, there's a study of children 6 and under who struggle with comprehending what happens in a courtroom. They can't understand what the output of this is, what's going to happen, what is the consequence of going on. So I think if you want to give some guidance to lower courts and to litigators, a general guideline could be that common law age of 7. I don't think there is a hand-in-hand relationship between Dr. Harry and Michelle Maddox. There are 4 people who work at this particular child protection center or child response center. Dr. Harry is the medical director. She gets referrals from all kinds of different people. She did not read Michelle Maddox's report. She conducted an examination with the child alone, without anybody else in the room, taking a history from her. And yes, she did talk to her about the difference between a truth and a lie, but I don't think that is particularly significant for a young child to emphasize to them, do you have a hurt? Tell me what it is. Don't hide things. She did testify that the forensic interview referral is helpful because that tells her that a forensic interviewer has seen a reason for this child to undergo a medical exam. Like I said, I don't see that they go hand in hand. With regard to the statement at the bottom of the final page of her report, I don't know why she included that statement about how many hours she spent preparing. This could have been a report that is prepared not just for the eyes of the county attorney, but for various peoples for purposes of reporting under federal statutes. I don't know. There's no testimony on that. I think it would be doing Dr. Harry a disservice to import into it any nefarious intent on her part.
Can I interrupt for just a minute? I guess I want to get one question out here, and I want you to have the opportunity to address it before your time's up. But when we talk about this protective service agency here and the grant funding, it's apparently funded by DHS and works closely with DHS, with the county attorney's office, other agencies that are involved in child protection, of course. But there just seems to me to be, and I'm referring somewhat to the dissent in this Court of Appeals opinion, where you do have this dual purpose there. Clearly the purpose of Dr. Hari is to do an examination and evaluation and for care and treatment and all that, and I don't dispute that at all, but there does appear to be this dual purpose of as being an extension of the investigative arm of law enforcement and or DHS itself for possible either prosecution or even child in need of assistance type of proceedings. And I just want you to be able to respond to I guess, my concern about that dual purpose there.
Well, the Supreme Court talks about the primary purpose of an interview. And I think you can have more than one primary purpose depending upon the situation. We do know from Michelle Maddox's testimony that there are several purposes to her job. One of which is an important one, is to educate the child. To tell the child, listen, if this happens to you again, you are to report it. If you see this happening, you are to report it. Don't hesitate in doing that. So there's an educational component to what she does. There's also a referral component. Again, in this case, she did exactly what she was supposed to do, is refer the child for ongoing physical examination by a medical doctor. I guess I don't know how else to answer that, because we didn't have any evidence in the record regarding the funding of this particular center. I understand your concern, but if you take State v. Bentley as a benchmark, there you have ongoing interrogation by the police during the interview. They confer before, during, and after. And one of the important things that I think is missing here that nobody has mentioned yet is that at no time does anybody tell this 4-year-old child, well, now listen, if you don't tell the truth, if you don't tell us the truth, and you lie, there's going to be consequences for this. There's going to be a penalty for you.
Counsel, was the admission of Dr. Harvey's, if we found that was a Sixth Amendment violation, was that harmless error in view of the testimony of the eyewitness, other children?
Your Honor, I believe that's true. We have 3 eyewitnesses to this case, young children, who testify about seeing the delinquent child on top of this 4-year-old who screams. They come into this upstairs bedroom and see the delinquent child on top of the victim with his hands somewhere on the front of her, and she is minus her shirt. One of the child says, "What are you doing?" And the child says, "Nothing." His face turns red, which is a pretty good piece of evidence, and then runs out of the house. In addition to that, you have some cell phone recordings involving him that show extremely disturbing images of somebody who is preoccupied with sex. So I think, as is indicated by the juvenile court, because the juvenile court says alone those 3 children provide persuasive testimony of guilt, that when it all comes down to it, the admission into the evidence of Dr. Harry's report was just, on a de novo review, you can certainly credit the testimony of those children and find that any error in admission of the report was harmless beyond a reasonable doubt. Thank you very much.
Mr. Kempkes, thank you as well. Rebuttal argument, Mr. Tupper?
Counsel, could you address that harmless error issue while it's very fresh in our minds?
The testimony at trial of essentially the children is certainly concerning. Having said that, I'm not sure that any of us can decide today, with the exception of myself, no one having been there, to assess the credibility of those children who testified. It would be difficult to simply exclude that testimony and then ask the court, what would you have decided? Oh, I guess we can't really ask that question. The court has heard all of this information, and simply saying, nope, we're not going to allow all that in, it was harmless, it seems to me the right answer is to reverse and remand. Let me go to another point, if I may. The state would have the court believe that this 4-person office with 2 professionals, a forensic interviewer and a doctor, were like 2 ships passing in the night, never having talked with each other. Now, in my practice, I see some 2-person firms with 4 people who are employed there. And if those 2 professionals are sharing a client, it is hard for me to believe there has not been some communication between them.
Dr. Harry testified there hadn't been?
She testified she had not read the report. She testified she had not read the report. But when you look at the forensic examination that's done by Michelle Maddox and the interview that's done by Dr. Hari, that elicits the same kind of information and, in fact, the same information, it certainly would appear that there is some commonality of purpose and goal and direction, however you want to say that. Other questions? If not, I
I'll
think...
just follow up with one, going back to my comments with Mr. Kempkes here. Again, what the Oregon court did in that case was talk about the dual purposes here, but we're really having to rely upon the U.S. Supreme Court because that's the only thing that we've been provided with here, at least as part of this case. And so then we're now, I guess I'm arguing against what I said before, but we have to look at the primary purpose of this. And so you're having to convince me then that the absolute primary purpose of these interviews by not only Miss Maddox but also Dr. Hari then were for the primary purpose of aiding in the investigation of this juvenile delinquency complaint. So why don't you tell me?
Well, certainly Michelle Maddox's interview, which was a forensic interview with the police in attendance, the primary purpose there had to be investigative and to aid the police. When you look at the fact with regard to...
Does the mere presence of the police then make it an investigation? I mean, obviously, this is relatively close in time to the incident itself, so we have the child, you know, if the police get involved, they take her to the emergency room, and of course, they're going to make a referral immediately to a CPC of this type, and I don't think it would be uncommon for them to at least accompany them, whether they're there as part of the investigation or not.
Several days later, several days later, the police accompany them to the interview with Michelle Maddox. They pose questions through the door. They provide information to Michelle Maddox ahead of time. Michelle Maddox conducts what's called a forensic interview and describes that forensic interview technique and elicits incriminating statements. To me, that's the primary purpose there is investigative. With regard to Dr. Hari, it seems to me the same argument is in place. It is not the sole purpose. She certainly goes through the process of a medical examination, but the medical examination has already been done at the emergency room. If the need was for psychological treatment, you don't go to the CPC for that or the Child Protection Response Center. You don't create a 4-hour visit and report for the purpose of a medical exam. You do that for investigative purposes. It seems to me that looking at the context of all of this as a whole, the primary purpose of both Barbara Hari and Michelle Maddox's interviews, exams, reports were to be part of the investigative process. And obviously the thank you to the County Attorney's Office for being involved in the assessment. You don't thank the County Attorney's Office for a mere physical exam of someone. Thank you.
Thank you as well, Mr. Tupper. The case then is submitted to the court, but before adjourning, Mr. Kempkes, I know this is your last appearance in our court, and I just wanted to say on behalf of the court, it's been a privilege to have you before us all throughout the years, and we thank you for everything you've done for our system of justice and for the way that you've done it. We wish you the best and congratulations.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.